Prior to some recent legally dubious phone searches at border crossings, I've never really had occasion to sweat giving someone access to my phone. Now, I fear pure sass would have me, a U.S. citizen, extradited to a country I have no ties to. I suppose we're all fortunate that I squeaked back into the country before the shredding of our constitutional rights began. At least now we know that should I vacation abroad, I'll take a prepaid phone without my usual detritus on it. But I recognize that as an adult who didn't have a smartphone until my senior year of college, I got a lot of growing up out of the way in the pre-digital era, and I've always been a shade more cautious than most. I'm a total rule follower, as I suspect many middle children obsessed with fairness are. That's all to say that it's not shocking to me that young people with access to the entire world in the palm of their hands sometimes retain incriminating evidence on their phones and might not realize that some things shouldn't be documented for posterity. That some paper trails can only cause them future harm. For Lance Corporal Nelson, it wasn't so much that he didn't realize how closely he should safeguard his phone, but rather that he avows he did not understand what his privacy rights were. This is Conduct Unbecoming. I'm Erin, and I'm your host. In April 2019, investigators hauled witnesses in for interviews on some unknown case aboard Marine Corps Camp Lejeune in North Carolina. While speaking with witnesses to that unknown crime, one of them let slip that they'd seen Lance Corporal Christopher Nelson consuming drugs. Criminal Investigative Division got in touch with Nelson's command, and a senior staff non-commissioned officer escorted him over to CID for a chat. The CID agent advised Nelson of his 31 Bravo rights and his Miranda rights, and then asked if Nelson wanted to talk. Nelson formally waived his rights to remain silent, signing the paperwork that admitted as much, and spilled. He admitted he'd consumed cocaine and said he couldn't rule out whether there was discussion of his ski trips on his phone. The investigator asked if he could poke around on Nelson's phone, and Nelson declined. So the investigator explained that his next step would be to seek authorization from Nelson's command to search and seize his phone. Nelson said that if it got to that point, he guessed he wouldn't have much choice but to turn over his lock code in order to facilitate the search. That conversation continued for another 90 minutes, during which the investigator asked a number of additional times for consent to search Nelson's phone. Each time he inquired, Nelson declined, at one point stating he'd be willing to, quote, let a lawyer look at my messages, which is probably a little bit imprecise. Prosecutors are lawyers, but I suspect he meant defense counsel because he declined yet another search request, stating he didn't want to allow a search of his phone without knowing whether he'd be incriminating himself. The investigator held onto the phone and allowed Nelson to leave after fingerprinting him. Consistent with that stated path forward, the CID agent went to Nelson's command and obtained authorization to search and seize that phone. That is, the commanding officer determined that there was probable cause to search Nelson's digital images, media, call logs, and text messages for evidence related to his cocaine use. Search authorization in hand, the investigator visited Nelson again at his command headquarters, presented Nelson with his phone, and asked whether he was willing to unlock it with the passcode. Nelson replied that he didn't think he had much of a choice, or maybe that he would do it if he didn't have a choice, then entered his passcode and unlocked the phone without waiting for any further response from the investigator. Inside, investigators discovered a trove of evidence of Nelson's wrongful use, introduction, and distribution of multiple controlled substances. And that should come as kind of no surprise. Our phones contain a great number of details about our lives. They reveal our locations, our reading habits, contain photographs of our day-to-day lives. When combined with wearable devices, our phones know how much we sleep, when our heart rates spike during the day, and when we're under periods of stress. Nelson's phone tattled on him in a big way, showing a 3-year history of conspiring with a fellow Marine and a civilian to distribute both LSD and cocaine to Marines in Jacksonville, North Carolina, and aboard Camp Lejeune. Nelson dealt those drugs on several occasions, but he was not above getting high on his own supply, using cocaine, LSD, and magic mushrooms in that same 3-year period. With the mountain of evidence piling up against him, Nelson elected to accept a plea agreement. He pled guilty to 1 specification of conspiracy to wrongfully distribute a controlled substance, 1 specification of conspiracy to wrongfully introduce a controlled substance with intent to distribute, 2 specifications of wrongful distribution of a controlled substance, 1 specification of wrongful introduction of a controlled substance with intent to distribute, and 3 specifications of wrongful use of a controlled substance. As a condition of his plea, he preserved the right to challenge the court's ruling on his motions to suppress the contents of his phone. Consistent with the litany of crimes that Nelson admitted participating in, the military judge sentenced him to 24 months of confinement, reduction from E3 to E1, and a bad conduct discharge. In line with the pretrial agreement everyone came to, the convening authority approved the reduction from E3 to E1 and the bad conduct discharge. Then they applied the sentencing cap and suspended confinement in excess of 18 months. I think the legal issue here is a bit more interesting than the naughty conduct. On appeal, Nelson argued that the military judge erroneously admitted evidence from his smartphone. But really what he challenged was whether the judge correctly determined that Nelson voluntarily provided the passcode to law enforcement. He described the investigator's communication that he was going to go get a search authorization from his command as a threat, which feels like an unfair description. Obtaining a valid search authorization or warrant is always a possibility, and it's not really a threat to say, I'm going to do this by the book and get permission to make this search and make sure that it's both valid and legal. It's not the same as, say, a threat to deport someone at the border for having a meme featuring the vice president on their phone. Nelson also alleged that he received ineffective assistance of counsel, arguing his defense counsel should have moved to suppress the evidence obtained from his phone based on a theory that the seizure after their first conversation was unlawful. But his counsel did try to suppress the phone's content, arguing specifically that Nelson's act of unlocking the phone was involuntary, highlighting that the investigator didn't give Nelson a fresh set of 31 Bravo or Miranda warnings, even though this second conversation was separate from the interrogation in which he received those warnings. At the court-martial, they'd also argued that because there's such difficulty in cracking a phone without the passcode, the evidence investigators found wouldn't have necessarily been inevitably discovered. So I think we need to refine our lens a bit to understand where Nelson thinks that his counsel went wrong. He thinks that his counsel whiffed and argued the wrong theory. Nelson labeled his counsel deficient because they did not move to suppress the data on a theory of unlawful seizure of his phone. He believed the investigator should have returned his phone to him after the initial 90-ish minute interrogation. He believed the seizure itself was illegal and that the incriminating evidence the investigators uncovered was fruit of the poisonous tree. But if the strong case from episode 26 taught us anything, it's that time is of the essence, and investigators shouldn't give an accused unfettered access to their electronic devices. When the court-martial judge assessed the record, they determined that based on the totality of the circumstances, when the investigator reapproached Nelson after getting command authorization for the search and seizure of his phone, it was a continuation of the first interrogation and did not require a fresh rights advisement. With that finding, it followed that the statements Nelson made during the conversation at his command headquarters were voluntary and a renewed waiver of his rights. For his part, Nelson maintained that he did not understand that a command search authorization did not compel him to provide access to his phone. He didn't realize he could decline to provide his passcode. We can't necessarily look at a defendant's stated subjective belief under circumstances like this. So instead we look to whether a defendant's will was overborne in order to determine whether the action was voluntary. The Navy and Marine Corps Court of Criminal Appeals determined that the totality of the circumstances showed Nelson was properly advised of his rights, which he then waived with his signature on the military suspect's acknowledgement and waiver of rights form. His repeated refusals during the 90-minute interrogation seemed to demonstrate that he knew and understood that he could say no. Not only that he knew and understood that he could say no, but that he was, in fact, comfortable saying no. He refused to allow the investigator to search his phone and also refused to provide a written statement. At the meeting the following day, where the investigator asked him to unlock his phone, their conversation consisted only of asking Nelson to unlock his phone. There weren't any threats or physical abuse or intimidation to get Nelson to agree. There simply weren't any indicia of coercion. Because that conversation in which Nelson unlocked his phone was not recorded, it's not clear whether he said he didn't have much of a choice or he would do it if he didn't have much of a choice. Either way, I think that statement would seem to indicate that he didn't understand whether he could decline to give the passcode and make the government crack it, or I guess give it their best effort. But the NMCCA concluded that was just one factor for them to consider, and ultimately, it weighed against Nelson that the investigator never said the search authorization meant that Nelson could no longer refuse to provide his passcode. So taking all of that soup together, they determined that the court-martial judge did not abuse their discretion in admitting the evidence obtained from Nelson's cell. And turning briefly back to that argument about the efficacy of his counsel, they determined that it wasn't an inappropriate seizure, and therefore his counsel was not ineffective for not arguing that. The Court of Appeal for the Armed Forces agreed that all signs pointed to Nelson voluntarily providing his passcode and affirmed. In their opinion, they highlighted that the investigator wasn't under any obligation to correct Nelson's misimpression about whether he must provide the code. Which I guess is just something to be aware of for anybody who may find themselves under similar circumstances. Thank you for listening. If you enjoyed today's episode, please share it. I invite you to submit case suggestions and feedback to conductunbecomingpod@gmail.com or on conductunbecomingpod.com. Join me next time when we tackle cold cases that warmed right up. Until then, take care. Conduct Unbecoming is a podcast where I get to talk about interesting crimes and cases that involve U.S. military service members. I research, write, and produce the podcast myself. The opinions expressed are my own, and perhaps it's obvious. Conduct Unbecoming is not approved, authorized, or endorsed by the Department of Defense. or because the department's name has not changed, but leadership announced that they have a new preferred name and we aren't monsters that dead name. It's not approved, authorized, or endorsed by the Department of War either.